Hello, everyone. I'm Vince White. I'm an employment attorney, and I'm here with attorney Ian McCrary, who has been, as I hear, helping a lot of people in the field of employment law. And I am super excited about that. He's got quite a pedigree. He was in house for a while, and that's a lot of knowledge to bring to the field of employment law, in my opinion. And we thought it might have value if we throw out a hypothetical and discuss how different attorneys might look at that case, look at the risk of that case, look at the valuation of that case, and how attorneys in our field, who frankly are in different jurisdictions, right? Like I'm right now sitting in New Hampshire, and sir, where are you?
North Carolina.
There you go. Different jury pools. And I practice primarily in New York, even though I'm sitting in New Hampshire, right? So we got vastly different jury pools. I think your jury pool is changing rapidly these days, based on my understanding. And that's got to be fascinating. And I thought that it might have value to the audience to hear how we have this conversation. So I'm very excited for it. Sir, the floor is yours.
Yeah, likewise. Thanks for having me on. I'm a big fan of what Vince is doing here and putting these videos out there to help different people. And especially since so many people are taking the cases themselves to the EEOC. And, I think it's very helpful to have an attorney's perspective. And he's given some great advice. And one of the videos I saw that he did was a very good 10,000 foot level view of valuation of a case. And so I got in touch with Vince and said, well, okay, let's see if we can dive a little bit deeper. And like he said, we're going to have different perspectives and we're in different locations, but I do agree that both of our perspectives can offer a lot of value, hopefully. So I came up with a hypothetical. And let's say you have a case where you have a supervisor, more or less, but I'm going to change these facts a little bit as we go to, if you listen to Vince's other video talking about, well, what is the likelihood of success in a case? Say, okay, well, how do these different facts, if they change, maybe reduce or improve what the case is worth? So we start out with a supervisor and an employee. They've been working together for about 2 years. Both are male, both about middle age, both Hispanic. And the supervisor had invited the employee over to stay at his house a couple of times, saying that, okay, you live 2 hours away, you come in and stay in corporate housing, 5 days a week. Let me offer you something a little bit homier. The employee is married with children, straight, never given any indication that he is homosexual or that he might be romantically interested in the supervisor. Well, one night the employee has sciatica that flares up and it's really hurting him. And so the supervisor says, well, here, I'm trained in therapeutic massage. Let me see if I can help you out. So the employee says, okay, I'm in a lot of pain. That would really help. So they start going and this happens. And the employer or the supervisor starts making some inappropriate advances, touching some areas that makes the employee a little bit uncomfortable. And the employee says, no, look, this has got to stop. And so the supervisor stops and that's it. Well, this happens on another occasion.
Ooh.
And this time it's because there's restructuring in the company. And this has been going on and kind of lingering over their heads for a few months. And the supervisor says, hey, look, I really need to talk with you about some of the restructuring changes and what that's going to require. And I need you to come over and sit down and talk about it. So he does reluctantly. And he makes plans to stay over that night as well in the guest bedroom. Well, the supervisor says, okay, I'm going to be your new official boss. He had always been the supervisor, but not on paper. There was a vice president who had actually been technically the direct report of the employee, but he delegated that function to this guy. And so now the boss says, I'm going to be officially your boss, and I really want to make sure that you're going to be loyal to the company. I want to make sure that, you're engaged and that you're going to do well in this new arrangement. So the employee says, okay, I'm definitely engaged. I want to do a great job. And they've been talking long enough that his sciatica starts to flare up again. So hurting badly enough, the employee starts to move around, definitely showing he's uncomfortable. And the supervisor says, hey, let me try to massage it out and help you feel a little bit better. And the employee thinks that the boundaries have been established, that he clearly communicated that he is not interested in this guy touching anywhere near any private parts. He just needs to focus on the area that's hurting, the nerves that are flared up. So they get into this, and all of a sudden the supervisor, without warning, pulls down his pants, peers in his underwear, and makes some creepy comments and gropes his penis. The guy freezes, doesn't really know what to do. And then a few moments later, when he kind of comes to, he quickly gathers his clothes, runs into the bedroom, and barricades himself. So the next morning, as much as he was dreading this, he has to see and talk to the supervisor to get out of the apartment. And they talk and agree that, okay, they're going to stay in separate places at work. They can do everything from separate offices. They'll talk on the phone. They'll be on Zoom calls together. That's it. Well, it goes on for a couple of weeks. And then all of a sudden, this supervisor starts coming into his office again, starts talking him up, doesn't do anything inappropriate, but at the same time, again, violates boundaries. And then all of a sudden, some adverse actions start to occur. The supervisor cancels a trip that the employee is supposed to have with the vice president. The supervisor also gives him a bad assignment when a international guest came in and asked him to do all of this driving around about 8 hours in a day, saying that the visitor really wanted to see this warehouse a few hours away. And then the employee learns that that really wasn't the case at all, that this was something that the supervisor had made up. And then the supervisor also undermines the employee in front of his team. And so kind of seeing the writing on the wall, feeling like his file's getting papered, that he's going to get terminated, he makes a complaint to the company. Company does an investigation, company fires employee, and then they think that's the end of it.
How soon after the complaint did the company fire the employee?
To use a legal term, I would consider it prompt, maybe 2 weeks.
And this is the plaintiff they fired, correct?
Correct. No. I'm sorry.
Oh.
This is the respondent. So they say, okay, employee, come back. Let's pretend like nothing ever happened. And so, I think from a legal standpoint, you and I would both agree that facts really bad in terms of what happened, but let's separate that from legally. If the company learned about it and then they do the investigation and fire the harasser, legally, the harm must be different than what the employee experienced.
Yes. Okay. So do you want me to run through my thoughts, or I guess you had mentioned earlier, you'd like me to run through my thoughts first. Is that correct?
Yeah.
Okay. I'm going to be very shorthand about this. I think you're going to note and perhaps even criticize me that a lot of this is not applied to the law. I'm giving you thoughts and feelings and notions of risk that I see, more so than my reading of the law. Because listen, that's a game for jury instructions, right? But that's you're going to try the case, you're going to embrace all the risk. We can have that conversation. But right now, we're doing a shorthand to some extent. Great fact pattern, tremendous harm, forcible touching, always key, always valuable. I would initially say, is plaintiff looking to make an exit or looking to stay?
Plaintiff's considering an exit. He's not really satisfied with the company anyway, but this was kind of the straw that breaks the camel's back.
Got it. So right off the bat, I'm going to just say it like it's in New York. Forcible touching, I'm at 6 years. Repeat forcible touching, right? I will also say I'm at 6 years of average earnings, because I have noticed over the course of my career that juries respond with a lot of ick, for lack of a better term, to massage cases. For whatever reason, all bad actors who engage in massage in the workplace are hated. I've never seen a case or a fact pattern where a creepy massage guy, which is what we have here, fared well. So I'm at 6 years. Now, couple of concerns. There is a tremendous predisposition in many pools of potential jurors to view men as likely closeted gay. For whatever reason, there's this like assumption, oh, he put himself in a situation, he experienced sexual harassment from another man, he probably wanted that. It's a different version of the she asked for it thing that we see in our industry. And it is kind of specific to men, especially men who are fit or attractive, or, you know, I don't know anything about this plaintiff, but I've seen that happen a lot. Gonna be honest, there's a major risk factor. First time, shame on the bad actor. Our plaintiff went back, right? And I say this as a fella who once worked for a man, very nice man, where I'd have to wedge a backpack under my door because he would make me sleep at his home the night before trial. And he used to make me mixtapes. Very nice man. But, you know, I knew to some extent what was going on. And the going back after the first forcible touching event, very sketchy. So you're making an argument that potentially he felt he had to, because now this is a direct supervisor. Complex argument, good argument. But then he also opted in to engage in the massage again. What's a massage cost? $200, $300. This fact pattern, this is tough, right? Like, yeah, the man made an unwelcome sexual advance to you and you didn't want to go get your pain treated for $300 by a professional. You opted in again while choosing to stay at his house again. And I will say, I think that would be something you could potentially sell. It's not a killer. Our case is not dead, but boy, it's a risk factor. I mean, I would imagine you see that as a tremendous risk factor. So, assuming your plaintiff wants a paid exit, and with all those risk factors, and if your plaintiff is like of the mind that, hey, I don't want public filings, I don't want to embrace all the risk of trial, well, you might start at 6 years, but you might secretly have a conversation with your client. Hey, 2 years, not so bad here, given what you want. And given, and it's tough, it's a tough conversation, given the choices you made, that the bed we're lying in these days, right? This is the situation. And I never want to victim blame, and I believe victims, and I believe him that he like felt he had to, or whatever it is. Pardon me, I have a terrible cough today. But that's such a narrative to sell. That is an uphill sell. And he's a man. And juries don't, in the lower 48 states, in my experience, give as much in emotional damages to men, specifically Caucasian men and African-American men. I don't know what this plaintiff's race is, but as they might to a woman or even another racial group, right? Like I've noticed that it's Caucasian African-American men receive less in emotional damages in the lower 48, not in Alaska, not in Hawaii. I don't know why, but I see it happen. I see it happen tracking over a decade. So in a complete dearth of information about your defense counsel, knowing nothing about defense counsel, which is somewhat rare in this industry, you've got to sell that. You've got a big fact pattern, big speed chest fact pattern. Oh my God, this is horrible. You know, the huge representation up front. I think you go with 6 years. But it's rotten. That's the wrong phrase. There's some amount of tremendous risk on the inside of that case. And if that plaintiff was my family member, and we're at the dinner table, take 2 years. That's my thought. And that's an ugly thing to say. I feel bad saying it, but that's our job a little bit. I think I'm hoping you have better news for me. Where are you at this on all this?
No, I think you're spot on in terms of your analysis. Setting aside the law, you have to do the practical analysis too, right? And how's this going to look to a jury? And I don't know how you do it, but often my wife is my jury,
Yeah.
right?
Yeah.
So sometimes I will, like when I was drafting up this fact pattern for a hypothetical, say like, okay, here it is. What do you think about this? He said, well, I think there's something more going on there. He went back again. You think he might have done something to indicate that he wanted that? Maybe he was feeling it out. It's like, oh, not what I wanted to hear. But that's the practical reality. I mean, that is who's going to be on your jury.
Yeah.
And so I think you're spot on with that analysis. Now, on the other hand, you got to sell it. So
Mhm.
sciatica flare up, that's a little different than, chronically being hunched over at work and needing a
Sure.
massage that you can schedule ahead of time.
Sure.
Being at night, I don't know how to get a hold of a masseuse, to
Sure.
set up a massage at 9 o'clock at night.
Hmm.
So the fact that he's his boss now officially, and the fact that they were doing restructuring and he doesn't know if he's getting fired or not, that he wants to make sure he's still got a place at the company. So can you sell it? Yeah, but what's going to stick in the back of the jury's mind? So
Yeah. And I agree
yeah.
with you straight across the board there. I think this is a winnable case at trial. If this plaintiff says, hey, I want the risk of trial, I don't mind the public filings. I think you already did it, and I certainly agree with you. You back that case. You front those expenses. You cover those expenses. That's worth the bet. That is a winnable claim. And if you win that claim, that could be a seven-figure claim. Let's be honest. Now, the counter to that is when that jury comes in, your heart is about up here in your throat, right? Like, oh boy, you know. And during that trial, you're gonna look over that jury, and there's gonna be people saying, just shaking their head at you. You're gonna, it's not gonna feel good. It's not gonna feel good, and you're gonna know why they're doing it. But it's winnable. It's just it's winnable in aggregate for you and I. Like we get many cases. So it's a smart bet. If you bring that case 10 times, you make money more often than not. And the money you make is probably fantastic when you hit. Right? It's great for us. Plaintiff only gets one. Right. So my recommendation for the plaintiff is based on they only get one. For you and I'm with you. We'd try that case. I would be guilty. I'd be the guy in my firm like, hey man, you don't have to take 2 years. We could roll the dice. And people in my firm would be like, don't listen to Vince. Vince is greedy. Do not trust Vince. Vince will try. It is what it is. And that happens in my firm all the time. So, but I think we probably have a consensus. Oh yeah, if you can, you try that case, right?
I mean, but let's be honest, that's what we do as attorneys, right? Is we
Yep.
help clients make informed decisions.
Yes. Yeah.
And we let them make the call. And so whether they want to roll the dice, say, look, if you want to, we'll do that.
Yeah.
But, if I can get you this right now, not so bad.
I do fully subscribe to that. Even when it makes my clients angry, I think that's true. I love the way you approach the case. I mean, obviously, because you agree with me. No, but I think you're so spot on. Do you want to tell folks a little bit about your pedigree, your background, so if they're in North Carolina, they can reach out?
Yeah, sure. So my background is working as in-house legal counsel for a large university for a number of years.
Oh wow.
And I managed litigation and I was involved in all aspects of that. I oversaw all the filing process and reviewed pleadings and motions and, went to court. And, one of the big benefits of that was that we often work pretty closely with our insurance companies and, they would point us out great attorneys to work with. And they would also have the benefit of knowing all of the confidential settlements that have gone on. And that's what Vince and I were talking about is when you're trying to value a case, most of these settlements are confidential. And so you don't necessarily know what other similar cases have gone for. And so you're trying to value the case and you have some rules of thumb, but the wealth of information that we had being in-house counsel and being able to tap into those insurance companies' databases was just incredible. But now my dad was having some health issues, and so I moved back to North Carolina, opened my own firm, and started doing what I've done, which is education law and employment law.
I love that. That's fantastic. Did you deal with a lot of Title IX when you were at the university?
Tons of Title IX. In fact, I was actually a Title IX investigator
Wow.
at Baylor University when they
Ooh.
had their issues going on. Um, just after I left legal practice, I did some litigation when I first started out, and then I really wanted to transition into higher ed and picked up a master's in higher education and took my
Okay.
first job down at Baylor. And then I went in-house counsel at Liberty University when they had everything going on with their Title IX, multi-plaintiff suits and Jerry Falwell and all of that fun stuff. So
Yeah.
I've seen some things.
I would love to do another, if you're open to coming on the channel. We'll see if you like the way this works out. But the level of Title IX representation across the country, in most of this country, not everywhere, it's horrific. It's often just general practice attorneys taking big checks off of desperate people and barely doing anything because they take like this. It's Title IX. It's kind of amorphous. It is what it is, and they just do nothing. And people will bring us these cases, and I'll look at them and I'm like, excuse me, how much have you paid this attorney? 45 grand. How? To do what? Like, and there's no result. And it's just, we're investigating. Well, the person should be graduated by now. What do you like? What? I'm getting worked up. I'm coughing more. I would love to do a collaboration on that. I would love to see your perspective on that. I'm excited you're doing it. Can I send people your way with Title IX cases?
Absolutely. I've got a
That's
couple of
fantastic.
Title IX advising cases right now. And,
Oh,
I think you're spot on, because what I noticed is that a lot of times what you end up seeing is survivor advocates representing the complainants, and
yes.
then the criminal defense attorney representing the respondent who's kind of posturing whether there's actually a criminal case or they think there's going to be one.
Yep.
And they don't know Title IX regulations, and they don't necessarily even look at the school's policies, and they're just kind of winging it based on what they have done in private practice. And I can tell you they're very different. And looking at it as an educational process, as opposed to a more formal criminal proceeding, makes a big difference.
There's a university in New York City. I'm not going to name it, and you might get a chuckle out of this. They will come to the accused, and they will say, and I've seen them do this, representing the victim, but just watching this is very strange. Hey, if you accept our finding and accept how we want this to end up, we won't report you to the police for the criminal charges. Excuse me? That's the game we're playing? And they've done it. I've seen them do it 5 times in 2 years. And it's a massive institution. And every time they do it, I just wonder what defense counsel is thinking. And 4 to 5 times, these people folded. And I get why they would, but that's strange and terrifying. It doesn't sound like, if you think it's criminal, report. That's important. You're doing everyone a disservice. You're doing truth a disservice. You're doing the bad actor a disservice. You're doing the plaintiff a disservice. Frankly, why wouldn't you have reported when it contemporaneously? What are we doing?
Yeah, and I wonder how that's drafted too, because I mean, technically, you have to report it even though it's anonymous in the Cleary report.
They put it in writing. I kid you not. I have it in 5 different files right now.
That's so bizarre. I've never heard of that happening.
It is insane, and it's just they think it doesn't matter enough. I think they just say, "Oh, we're just gonna be done."
So does the
I don't know.
complainant
What?
also agree? Is it like a mediated type of informal resolution where the complainant says, okay, I'm going to be happy with you being found responsible in this proceeding, so I also agree to not report you?
They do. They seek that from the complainant.
Wow.
Yeah. Which is very strange. And I also don't understand why going in, I've seen Title IX cases where the paperwork on the way in is like, hey, remember, this is not a criminal process. You may want to speak with the authorities, and that's best practice to my mind. Just nothing. We'll handle it. Everything goes through us is the gist of the opening paperwork. And then, hey, we've reached a resolution. We want you to sign off on it. We think you're going to like it. Bad actor, if you accept it, we're not going to report you. Plaintiff, if you're going to sign off on this, you're not going to report. Don't think that's in compliance with a variety of different requirements, but it is what it is.
Do you also think that would be enforceable if the complainant turned around?
No, you can't keep someone from their criminal rights. Like it's nonsense.
That's what I was thinking.
Yeah.
Yeah.
Anyways, I would love to do that collaboration with you. Thank you for coming on the channel. I'm going to have all your links down below. I want people to be able to find you. Anything else we should hit on today?
I don't think so. I mean, it's been great. I appreciate you inviting me on it. Again, I appreciate what you're doing.
I'm so excited. I'm so excited you're down there in North Carolina. I'm excited you're helping people. I'm excited it's going well. I'm excited the kind of gentleman who would make a life change to help family is in this field. That makes me super happy. It also makes me happy because I love having someone I know in North Carolina, because North Carolina is changing so quickly, right? Like it's almost city by city, as I understand. We have a couple cases in North Carolina, and you have conversations with local counsel, like, yeah, so that's in Asheville. So that's this and that. And you're just like, oh, it's city by, it's like New York almost. Well, this is in the Bronx, so we're going to win. This is in Staten Island, so we're in trouble, right? Like it's almost that level of differentiation, as I understand it. So I love knowing that I can reach out to you and have that conversation, and that you have the local expertise there. I'm very excited about that.
Well, and likewise up in New York, I just got a call from a client in New York today.
Come on up. The water's fine.
Yeah.
All right. Well, I love this. Please consider coming back. We're thrilled to have you anytime you come back. And it was just great having you.
Yeah. Thank you.
All right. Have a good one.
You too.